Hello, and welcome again to another of our short teaching videos from the Tenant Farmers Association. My name is George Dunn. I'm the Chief Executive of the Tenant Farmers Association, and this teaching is part of a series of teachings during which we try to shine a spotlight on topical issues being faced by the tenanted sector of agriculture, and it forms part of our growing YouTube library, which also features our webinars and news updates from the previous weeks. So don't forget to go and like and subscribe to our channel so that you don't miss out on any of the important new content as we post it. Now, today, we're going to be looking at some of the practical issues around tenants' fixtures. And I'm absolutely delighted to be joined by Julie Robinson, who is the head of agriculture at Roythorns Solicitors, who will be taking us through that topic today. Roythorns are also very kindly sponsoring our virtual teaching sessions throughout 2024. And for those of you who don't know the firm, Roythorns is a national law firm steeped in agricultural history. They've got 90 years experience of advising landlords, landowners, and tenants. And their lawyers are very active in many policy forums, so they very much get the bigger picture. So whether it's about tenancy succession, or it's about a new FBT agreement, a new farm business tenancy agreement, or a dispute with your landlord, or a share farming agreement, or looking at natural capital agreements, Roythorns is there and able to advise. So moving on to today's topic, we're looking at tenants' fixtures and the different treatment of tenants' fixtures between the two principal pieces of legislation, the Agricultural Holdings Act 1986 and the Agricultural Tenancies Act 1995, and what we need to be watching out for. Now, please be aware that this is being recorded in the summer of 2024, so everything we cover today is correct at the time of recording. So for advice on individual issues or circumstances, we do recommend you contact the TFA and ask to speak to one of our advisors. So without further ado, I'd really like to introduce you now to Julie Robinson, who, as I mentioned earlier, is the head of agriculture from Roythorns. So we are delighted to have her today. So Julie, over to you to talk to us about fixtures.
Thank you, George. And thank you to everyone who has tuned in to watch this teach-in session. Could you put up the first slide, please, Julia? Thank you. So I thought it might be useful to have a look at tenants' fixtures and issues in practice. I have to say there's an excellent TFA teach-in on improvements and fixtures already on YouTube and available to watch, and I would recommend watching that. My focus here is on some matters that have come up in my own practice. And again, normally you would expect, and I would expect, agents to deal with tenants' fixtures. We, the lawyers, we document the position. We don't often spend a lot of time advising or worrying about tenants' fixtures within tenancy agreements. But there are some issues that have come up, and I'm going to have a look today at old tenancy, new tenancy changeovers, farm business tenancies and the tenant's right to remove fixtures, and at just some almost tips for good practice. We have a new code that focuses on clarity and communication in particular, which I think is particularly useful in this area of tenancy agreements. Next slide, please, Julia. So this is, in a sense, the risky part. This is where things can fall through the gaps. When there is a tenancy changeover, when one tenancy ends, another tenancy begins, and we have different tenants. And they may not be related. These may not be family successions. These may be completely arm's-length tenants. So the position on tenants' fixtures, it does need to be agreed and documented as far as possible. And we've got an outgoing tenant and we've got an incoming tenant. I'm interested in the incoming tenant's position, but of course, if there's an outgoing tenant, they have to do certain things, or they have a right to do certain things. If it's an Agricultural Holdings Act tenancy that has ended, then the tenant under that tenancy is obliged to offer the fixtures to the landlord. That isn't true of farm business tenancies. What you will often see is a deal between the outgoing tenant and the incoming tenant. And that counts, that enables the farm business tenancies, that enables those fixtures to be considered the new tenant's fixtures and his property, and he has the right to remove them. Because he's actually paid for them, or paid some consideration, given some consideration to the outgoing tenant. However, actually, the tenant may not have much choice in this, because the landlord may simply have presented the holding and advertised the holding as it is, and with the previous tenant having no part in the conversation. And also, the parties may prefer a clean slate on fixtures. Why would that be? Well, as I say, they might not have any choice anyway, but the incoming tenant actually may not want to have the responsibility for the fixtures that were put in by the outgoing tenant. They may not be useful to him, and he may have repairing liabilities under the farm business tenancy. So it's not always an open and shut case whether the incoming tenant wants to acquire the fixtures from the outgoing tenant. Next slide, please, Julia. So let's just have a look at farm business tenancies and the tenant's right to remove. And this is in contrast with the position under Agricultural Holdings Act tenancy. What does the Agricultural Tenancies Act say? It says the tenant can remove fixtures at any time during the continuance of the tenancy, or at any time after termination of the tenancy when he remains in possession as tenant. Okay. Now, that remaining in possession as tenant may mean, for example, where a renewal tenancy is granted. So it simply continues on, and it will follow through and continue through. I'm not sure whether a holdover license would be sufficient, but in practice, I'm sure people treat it as being sufficient during a period of holdover. So this is an important right for the tenant. These belong to him, or to them, to the tenant. There are some restrictions on removal, though, and these are important. So the first is, if the fixture or building is in place of a landlord's fixture or building. Now, that sort of reads quite clearly on paper. It's a little bit more complex in practice, particularly where it's what the tenant is adding and fixing is an extension or sort of cuts into one of the existing buildings or fixtures of the landlord. Second restriction on removal is if the fixture is compensated as an improvement. Obviously, at that point, that has been by agreement, and that fixture then belongs to the landlord. He's basically bought its value from the tenant. And finally, if the landlord has given consent, conditional upon non-removal as a fixture. So we're not talking about this becoming an improvement. We're just saying, landlord says, yes, you can do that as long as you don't remove it. And of course, from a tenant's point of view, it's going to, whether how he takes that forward will depend upon the value of that fixture he is putting in, how easy it is to be removed, etc. Next slide, please, Julia. So finally, tenants fixtures, some good practice. And again, this is about the position being clear for everyone. And it is also about having discussions, which I know that tenants find difficult with landlords direct, or particularly actually with landlords agents sometimes. I think it's really important, it generally happens, it's just that it sometimes doesn't, to distinguish on changeovers between tenancies, between improvements and tenants' fixtures, between what is an agreed improvement that the tenant can be compensated for and what is the tenant's to remove, and do full lists. Check your tenancy agreement for whether consent is needed for alterations to the holding. If it is, then have the discussion. And if you're replacing, or particularly replacing or part replacing a landlord's fixture or building, have the conversation so that, again, it's very clear what is happening, and document it well, take pictures, etc. Take agent advice on the pros and cons of seeking landlord's consent for treatment as an improvement. That will depend on a number of factors. And consider very carefully before leaving worn out fixtures when you leave the holding at the end of a tenancy, because if the landlord has to remove that fixture and there is damage to the holding because of that, and it costs the landlord to remove it, you may face a dilapidations claim from the landlord for that. Thank you very much, Julia. That's the end of the presentation.
Julie, thanks so much. A tour de force in such a short space of time there. Just a few questions for you. So you mentioned in passing at the beginning of your presentation the new code of practice for landlords and tenants on agricultural tenancies, which has arisen out of the ROC review into agricultural tenancies and was published a little while ago now. What do you think the impacts for that code of practice will be on professionals in practice, like yourself or agents? And will it make a difference to the communication between landlords and tenants' professional representatives?
If I'm honest, George, as you can imagine, we spend a lot of time when we're instructed by our clients fighting our client's corner. That's what professionals do under our retainer with the client. Now, having said that, our professional associations, and indeed some of the large agency firms, have endorsed the code of practice. And the code of practice is exactly that. I mean, it reads and it makes, it's common sense, really, but with a focus very much on discussions and clarity. I can see it being used by professionals more where they feel the other party is in breach. So used in anger, really, rather than used proactively. And it may also, I think, being realistic, also be used in a conversation with the client, where a client instructs you to do something which may not be top level of good practice in terms of communication or clarity. Simply because it would be embarrassing for there to be some kind of allegation under the code that you had not followed it. No firm, no professional really wants to be accused of that.
Okay, so coming back to the changeover of tenancies, I think you've been clear that the position on tenants' fixtures needs to be agreed at changeover. Now, if for whatever reason that doesn't happen, can the parties go back to document things at a later date?
So, of course they can. A tenancy agreement can also be varied, or there can be a memorandum. I mean, often, as you know, fixtures improvements will be dealt with by memorandum. You're not going to go back and vary the tenancy. You're simply going to have something in writing that shows the position. So, of course, they can. The issue for me is why would the landlord in particular want to go back and say, oh, yes, no, I agree, that's a tenant's fixture, when actually it's come back to the landlord on the termination of the previous tenancy. And therefore, rent review, it's part of what the landlord is letting to the tenant. So it's more a question, of course it can be agreed later. And it really, again, would come down to relationships between the parties. If there was an error, something overlooked that was meant, that got lost in translation in the agreement. But as I say, I can't really see, if I was acting for landlord, why we'd agree that.
Okay, so this is probably one you're going to tell me is more for the agents. But if you have a tenant who's made an alteration to a landlord's building without the landlord's consent, which is breaching an obligation in the tenancy, what are the potential consequences at the end of the lease?
Well, George, this is usually one for the agents. But look, if you think about it, if there is a clause, a provision in particular, you find them in farm business tenancies, in the standard farm business tenancy templates, which says that the landlord wants to keep control of what's there on the holding. That will say no alterations, no additions, no buildings, no extensions without landlord's consent. If the tenant goes ahead anyway, potentially at the end of the tenancy, there could be a dilapidations claim, or the tenant can be required, even during the tenancy, to reinstate because they've done something without the landlord's consent. Now, of course, in practice, this is where the agents come in. They'll take a view and go, but this is a better building with what the tenant's done. You know, there's a nice ramp here now that there wasn't there before into the building, or that partition of the barn works much better. So that's where, in a sense, the tenant also wants to be taking advice from his agent about whether something should be consented by the landlord, even as an improvement, rather than just a fixture.
Thanks, Julie. I think we better try and wrap things up there. Thank you. So if you are watching this and you've got some more questions about your individual circumstances, why don't you become a member of the Tenant Farmers Association? So membership is really good value for money. It's just £249 per year. And that gives you access to dedicated advice, information, and support from our TFA professional rural surveyors that we employ here. Now, for more information about the TFA and how we support all farmers in England and Wales who don't own the land that they farm, you can go to our website, www.tfa.org.uk, and you'll find information there about our calendar of events, as well as our latest news, and also obviously how to join the association. So we really hope that you found this teaching useful. Let us know in the comments section below what you thought of this short video. And don't forget, as I said, to like and subscribe to our YouTube channel so you don't miss out on any of the new content as we post it. So many thanks again to Julie and to Roy Thorne Solicitors for sponsoring our virtual program. And we look forward to seeing you again. Goodbye.